What do you mean you don't know if the work is finished? Hi, my name's David Richards. I'm a solicitor at Leeds Prior. I specialise in construction law. I'm doing a series of videos on cases that have recently come out that affect the construction industry. This video I'm going to focus on practical completion. There have been a few cases come out recently on practical completion. I'm going to talk about one case in particular, Mears against Costplan. Practical completion is a core concept in construction. It relates to payments, it relates to insurance, it relates to limitation. Limitation date starts at practical completion for most causes of action. Being such a core concept, you would have thought that it was adequately defined either in the construction contracts or as a matter of law. Unfortunately, that's not necessarily the case. Most people use a rule of thumb. So most people in the construction industry use a rule of thumb that if the property is capable of occupation, then practical completion has been achieved. Now that's okay as a rule of thumb, and a lot of the time that will probably be correct, but it's not how the courts have interpreted practical completion. And I'll look at how the courts have interpreted it in a moment. JCT doesn't define practical completion in any detail. It just says when practical completion has been achieved, the employer or the architect will certify that practical completion has been achieved. In NEC contracts, you can make it a bit more specific. You can specify the work that's required before practical completion will be achieved. And if you don't do that, then you're back to a similar exercise of trying to make a factual inquiry as to whether completion has been achieved. So you're in a very similar boat. There has been some guidance over the years on practical completion. It's been around for as long as people have been building things. Courts tend to say that if there are de minimis defects, then practical completion can still be certified. The case that's often cited for that is a case called Neville Sunblest against William Press. That goes all the way back to 1981. Certain other cases that deal with other aspects of practical completion. The case that I was going to talk today about is Mears against Costplan. The decision was handed down on the 29th of March this year, 2019. In that case, Lord Justice Coulson gave a series of bullet point guidance on practical completion. So the first point that he made was that practical completion is easier to recognise than define, and there are no hard and fast rules. He then gave some hard and fast rules. We're not going to criticise him for that. He is a judge after all. He likes the rules. The next point that he made was that the existence of latent defects cannot prevent practical completion. That ought to be obvious. If defects are latent, as in you don't know about them, then you don't know about them, and therefore completion is always going to be achieved if those latent defects are there. But that's the second point he made anyway. Third point is that in relation to patent defects, or defects that you can see, there is no difference between an item of work that has not yet been completed and an item of work that is defective. There's no difference. A snagging list can contain both of those things, and practical completion is not necessarily prevented by the existence of either. What matters, in Lord Justice Coulson's view, is whether those defects are trifling, whether those patent defects, whether those clear defects are trifling. And whether or not an item is trifling is a matter of fact and degree, taking into account the purpose of allowing the employer to take possession of the works and use them as intended. So in assessing whether the work is trifling, you should take into account the purpose, which is for the client to occupy that building, residential, commercial, whatever. But whether or not the property is actually capable of being occupied is not necessarily determinative, and it is not necessarily sufficient. The final point that Lord Justice Coulson made is that an irremediable defect, so a defect that's not capable of remedy, does not prevent practical completion. So just because the client has to live with something that is defective does not mean that practical completion cannot be achieved. There's no easy answer to practical completion. You can attempt to draft amendments to the main contract or your own bespoke contract that has a definition of practical completion that can be relied on by both sides, and you don't then have to be looking at the common law definition. Some recent cases have highlighted the dangers of doing that. One case is University of Warwick against Balfour Beatty. But it is still possible to do. The guidance, though, given by Lord Justice Colston is probably the best starting point for anyone that is in any doubt as to whether their project has achieved practical completion. And that's it for today. My name's David Richards, Leith Prior. Any questions, please feel free to give me a call. Have a look on our website, www.leithprior.co.uk. Thank you very much.